Welcome back to our channel. I'm Chelsea Kennedy, the Executive Practice Coordinator here at Butler Wills and Estates, and today we'll be talking about releases and why an executor should get one. Releases are used in many areas of law, but for this video we're looking exclusively at using releases in an estate. So let's take a look at what a release is and why an executor should get one. What is a release? A release is a document used by executors and estate administrators when they're ready to distribute some or all of the estate to the beneficiaries. For the purposes of this video, the terms executor and estate administrator are used interchangeably and mean the same thing. Let's take a closer look at what's involved with a release. In a nutshell, the release says that the executor has done the work that he or she was supposed to do and that the beneficiaries are satisfied with the executor's actions. There is no formal way to close an estate. Many estates are started by applying for probate or administration, which gets the ball rolling and puts someone in charge. However, there isn't really a specific way to end an estate. Most estates are finished informally when the executor has given all of the beneficiaries their inheritance. A release is one of the ways an executor can be let go from the role of executor. The name of the document sounds like exactly what the document does. It releases the executor from liability. This is the easiest and least expensive option for releasing an executor. This document protects the executor from future legal action by the beneficiaries. Once the release is signed, the beneficiaries cannot come back and say that the executor has made a mistake on the estate. The document is also helpful for the beneficiaries. The supporting documents give them all the information about what happened in the estate, including both money going in and coming out of the estate. In turn, the beneficiaries receive their inheritance once the release is signed. There are two parts to a release: the supporting documents, also called the executor's accounting, and the release itself. The supporting documents are only provided to the residual beneficiaries. This is because their share of the estate is directly impacted by the transactions in the estate. Beneficiaries who are receiving a specific item or sum of money aren't usually affected by the transactions in an estate. Let's look at each part in more detail. We'll discuss these documents more thoroughly in our next video series, but they are important for understanding releases. The executor's accounting. This is a summary of all of the actions the executor has taken on behalf of the estate. It includes the dollar amounts going in and out of the estate and what each amount is for. The accounting should show how much the estate started with, what happened along the way, and how much is left to be divided among the beneficiaries. It should also show if any amounts are being held back and why. Statement of proposed distribution. This shows the calculation of how much each beneficiary will receive. If there is a will, this is based on the distribution in the will. For example, if the will says to divide the estate equally among my kids, and there are 5 children, the amount available for distribution is divided equally among the 5. If there is no will, the administrator needs to follow the provincial intestacy law to determine who the beneficiaries are and how much each person will receive. Statement of proposed executor's compensation. This shows the calculation of how much the executor is taking as payment for the work that he or she has done. If the will specifies a percentage or dollar amount, that is the amount that the executor is allowed to claim. Keep in mind that reimbursement for out-of-pocket expenses is separate. If there is no will, or the will does not specify an amount, the executor may claim between 1% and 5% of the gross value of the estate. Generally, simpler estates are at the lower end of the scale, and more complex estates are closer to the 4 to 5% range. There are two parts to the release: the release itself and an affidavit. The release is signed by the beneficiary in front of a witness, and the affidavit is signed by the witness with a commissioner for oaths or a notary public. We'll start with the release itself. When the beneficiary signs the release, he or she is stating that they do not have an issue with any of the work the executor has done. This means that they approve of all of the financial statements and all of the transactions that the executor has done. Most often, releases are used at the end of an estate, when all the work has been done. For more complex estates, there may be an interim distribution. This distribution would have its own release for the time period from when the estate started until the distribution is made, and this kind of release will still have supporting documents. The executor cannot ask the beneficiaries to approve of work that hasn't been done yet. The beneficiary has the right to have the release and financial statements reviewed by an estate lawyer or an accountant. It is important that the beneficiary fully understand what the documents contain, because signing the release means that the beneficiary is signing away his or her right to contest the accounting in the future. The release is not valid if it's not properly witnessed. The witness must be an adult who has his or her mental capacity. The witness also should not be the executor. It's questionable to have the executor witness the signing of a document that releases the executor from liability. The witness can be a friend or family member, even if that person is also a beneficiary. The affidavit is signed by the witness with either a commissioner for oaths or a notary public. When the witness swears the affidavit, he or she is saying that they know the beneficiary, they saw the beneficiary sign the release, and that the beneficiary is over the age of majority. The witness is not swearing as to how much the beneficiary is receiving. This is private information and does not need to be shared with the witness. Often, people choose to go to a local law firm to sign the release. This is because there are many people there who can act as the witness, and also they can have the affidavit sworn at the same time. Once the release is completed, the beneficiary should return the original to the executor to be kept with the estate records. It is a good idea for the beneficiary to keep a copy. Once the executor receives the completed release, the estate can be distributed. The release says that the beneficiary has received the amounts owing, but in reality, this step is often completed in two parts. First, the beneficiary signs the release and sends it back. Then the executor does the distribution. If either party has reservations about this process, a third party, such as a lawyer, can be used as a middleman to do the trade-off. Sometimes the beneficiary doesn't want to sign the release. What happens in this situation depends on why the beneficiary won't sign. If the beneficiary has questions about the financial statements, the executor can provide additional information. Sometimes this means sending receipts or explaining a particular transaction, such as the sale of property. If the beneficiary has a problem with the accounting and thinks that the executor has done something wrong, the beneficiary has the right to retain his or her own lawyer. This can mean that the estate ends up in court for the executor to pass the accounts in front of a judge. If the executor is using an estate lawyer, the lawyer can prepare releases. If the executor is not using an estate lawyer, he or she can prepare one. However, templates are not readily available online. In our office, we have mini kits for releases available on our website. They are published for each province, and each kit comes with an explanation of how to use the kit and the release, a blank template release for you to customize, a completed example of a release, and instructions for completing the release. Where to find us? Visit our website at butlerwillsandestates.com or send me an email directly to chelsea@butlerwillsandestates.com or give us a shout at 709-221-5511. If you like this video, make sure you click that like button. And if you want to see more videos about estate law topics, make sure to click that subscribe button. If you're already subscribed, be sure to click the bell icon so that you get a notification every time we post a new video. Stay tuned for our next video series about the different supporting documents that go with a release, and thanks for watching.